Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. In the last episode, we discussed the infringement proceeding from the perspective of the patentee. In this video, we will discuss various provisions available to the alleged infringers during the infringement proceedings. So here is our actor who might be involved in one of these activities and might have sensed some troubles with regards to a patent that got recently granted. Now, in order to avoid any future troubles, the actor would want to take some proactive actions so as to continue doing the activities without any issues. So what options does he have? As per section 105.1, a person can approach a court with the request to issue a declaration that the activities as performed by the person do not and would not constitute an infringement of a claim of a patent. But there are few requirements that need to be met before approaching the court. First, the person should have approached the patentee or exclusive licensee with a request to issue such a declaration by providing relevant documents and all related information pertaining to the activities performed by the person. And the patentee or the exclusive licensee ignored the request or refused to provide such a declaration to the patentee. In such a case, the person can approach the court with such a declaration request. Another requirement is that the patentee should not have already instituted a suit of infringement against the person. In such case, the person cannot approach the court after a case has already been instituted. So this is the proactive measure that the person can take to avoid any future trouble with regards to infringement of a patent. Now, a few details with regards to such a suit are that all the cost incurred by all the parties during such a suit will be borne by the plaintiff itself, the person who has approached the court. And the validity of the claims will not be discussed during such a suit of declaration. And the issuance or refusal to issue such a declaration by the court will not imply anything with regards to the validity or invalidity of the claim. And finally, such a declaration suit can be filed anytime after the grant of the patent. Moving on to another case where the patentee might be aggressive in terms of enforcing their patent rights. They might be issuing advertisements or issuing circulars or issuing communications, oral or written, directly, indirectly to other players in the market, stating that such and such activities infringe their patent rights, and if the activities are continued, an infringement proceeding would be instituted against them. Now, as a market player, you might get threatened by such an activities performed by the patentee. What do you do? Now, you can approach a court as per section 106.1 with the request to issue a declaration that such threats are groundless and such threats are unjustifiable. And you may also request the court to put an end to such threats. Basically, pass an injunction order preventing the patentee to continue with such threats. You may also seek damages, if any. But of course, if the patentee or the defendant in this particular case are able to successfully prove that the threats were against the activities which indeed were infringing in nature, then such a declaration will not be passed by the court. An interesting trivia at this stage is a mere notification sent to somebody informing that a patent has been granted on such a technology will not be considered as a threat. Now, moving on to a case where a patent infringement suit has been instituted by the patentee. I have to deal with it now. So what defenses do I have? Recollect from all that we discussed in the previous episodes. As per section 64, the grounds of revocation can be used as the grounds of defense. We can invoke any of those grounds to invalidate the patent, isn't it? Or we demonstrate the differences between our product and our process and as claimed in the patent. If there are substantial differences, there is no infringement. Or the activities indeed are covered under section 47 or 107A. So with this, we have discussed the infringement proceeding from the perspective of patentee as well as the alleged infringer. Please join me in the next set of videos where we discussed various other sections of the Patent Act. Till then, be good and take care.